Welcome to Representation Without Taxation with Jill McBride Baxter, a veteran sports law attorney for the past 30 years.
I'm about three things: protection, advocacy, and trust.
Not only is Jill an attorney, she's the daughter of a college football coach and the wife of a college football coach, and she knows all of the issues from all angles. This is Representation Without Taxation, a one-of-a-kind show featuring critically relevant material for contract employees in sports.
So glad you're back again this week. Last week we covered the topic of how to increase revenue in your athletics department. And this week we will continue the conversation about the house case with my law students. Specifically, the students this week will be addressing, one, how to define a booster, or the new term is what is actually an associated entity. We also will discuss arbitration and whether or not the arbitration system that they have presented in the house case, whether that's going to work. And all my students go back and forth about whether or not all these deals are pay for play versus actually a valid business purpose. And it's great having them on, and it also gives you a little peek into the course I teach. Once a year now. I'm going to teach twice a year for 1 week at McGeorge School of Law. So I hope you enjoy it, and I hope this information is helpful.
My class, Sports Law in Practice, here with me to solve the implementation of the House versus the NCAA settlement. I'm going to explain to my listeners right now that here is what the settlement ended up being, although it still has not been confirmed by Judge Wilkins. That is supposed to happen in April. I want to be clear about that to my listeners. But here's what the settlement is. Former athletes will receive $2.78 billion in back pay over a 10-year period. This is primarily for athletes who played between 2016 and 2021. Media, ticket, and sponsorship revenue with their student athletes. This could result in schools sharing between $20 million and $30 million with their athletes. Schools are not required to participate, but if they do, they must share with all athletes in their department. 75%, this is what the settlement says, 75% is recommended to go to football, 20% is men's and women's basketball, 5% is going to other athletes. Just so people are clear, and my listeners are clear, this is a permissive suggestion. It is not required. So schools can choose whether or not they want to share revenue with their athletes. The third part of the settlement is NIL deals. NIL deals will be questioned on associated entities and individuals, and they must be approved through a third-party clearinghouse. And an arbitrator will determine whether there is a valid business purpose or pay-for-play schemes that are disguised as NIL agreements. There's a lot of controversy surrounding this, whether this is going to work, and we're going to talk about this today on my podcast. The other part of it is schools will now be able to enter into NIL deals directly with student athletes with some limitations. This is, again, back to the arbitration. If it's over $600, it will be subject to a third-party arbitrator to determine whether the deal is fair market value or pay for play. We are going to talk today what fair market value means or pay for play. That is a huge debate right now going on all over the country. What does that exactly mean? The other part of the settlement that many student athletes are not happy with is the roster limits. The NCAA will adopt new roster limits which will replace scholarship limits. For example, football will have 105 roster spots, men's and women's basketball will have 15, and baseball will have 34. So roster limits are, again, part of this settlement. The timeline for the settlement is on October 18th, 2024. Former players were notified of the decision and the claim period began. On December 17th, the amount of money to be distributed will be publicly available. On January 31st is the deadline for people to submit claims, opt in, or bring objections. On April 7th, the court will hear the final approval. If the final approval goes through, in July of 2025, this will go into effect. Settlement that has to do with the arbitration. And what exactly, one of the things that Judge Wilkins talked about in the initial settlement hearing was that she did not like the definition of the word booster because she felt like everybody was going to be a booster. Some of my students in my class have researched this. By the way, in the next part of the settlement, when the lawyers came back, they defined this more clearly. So can you guys introduce yourselves and tell me how that was clarified as far as it comes to the arbitration and who is a booster?
Yeah, definitely. So my name is Malea.
And my name is Zach.
So just like you said, the original settlement was actually rejected by Judge Wilkins because the term booster was vaguely defined. And Judge Wilkins feared that current athletes with existing deals with boosters would be harmed by this language. So the parties actually replaced the term booster with associated entities and individuals to get that preliminary approval from the judge. And so in the amended settlement agreement, associated entities, in short, are organizations that exist primarily to promote or support a specific institution's athletics program or student athletes, or to create NIL opportunities for them. Or an associated entity could be an entity that is owned, controlled, operated by, or otherwise affiliated with another associated entity or associated individual. But unless it's a publicly traded corporation. And then to qualify for as an associated individual, the person must meet 3 conditions. They have to have a defined relationship with an associated entity, so that could be a member, an employee, some sort of agent, and they have to have made significant financial contributions exceeding $50,000 over their lifetime, and they have to have been involved in recruitment or the retention of student athletes, either through the direction by the athletic staff or through independent efforts. So I know Zach has some ideas on the potential effects of this change, or how might this play out in practice.
Yeah, Zach, how do you think this is going to play out?
Yeah, I think it's important to look at kind of what the implicit intent of that kind of those rules are.
The definition?
Of the associated entity. And I think it's kind of bifold with the NCAA and also just with the universities as well, as a way to kind of combat the parity in college football, to make sure that there's an even playing field. Because when you're comparing an entity like a University of Georgia or Alabama with a local school like Sac State, the treasure trove of these collectives that are going to be able to access alumni or donors exceeding that $50,000 benchmark is going to produce a disparate effect on the actual field. And I think that is the intent of kind of putting this wording as the definition of associated entity, to try to level that playing field and not kind of allow some of the schools that have access to these large donors rampant ability to create a pay-for-play system where the football players are coming to that school enticed by a high dollar amount without any connection to a business pursuit of those donors. So there's going to be a disconnect on that. And I think that's one of the main reasons why these definitions are in place. And that was a big part of defining booster, quote unquote, and associated entity more narrowly. And I think an effect of that is that boosters have been around for a long time. And I think it's kind of this untold secret that they've always been around, and I think they've been around before it was legal. So kind of going forward, shedding a light on these type of donors that have access to unlimited funds and can entice young, impressionable athletes to come play at their school for a high dollar amount, and kind of trying to put a limit on that, a governor, so to speak, to limit their impact on recruiting these individuals. And those boosters now are going to have to be a little bit more creative in how they structure their NIL deals and how they structure their payments, because I think we're talking about it later, but if they are putting that money into a collective, those deals are going to be scrutinized pretty heavily by the clearinghouse and third-party arbiters to determine if those deals really reflect the fair market value of those players, or if it's truly just I'm going to give you X amount for you to come play running back at my school, in the hopes that that is going to create a better football program, which is, I think, what the NCAA and the court is trying to avoid.
Okay, so here's my question to you. When I heard the definition, I thought to myself, $50,000 over a lifetime. Let's say a family has had season tickets for 30 years. They've had the same tickets in the stadium, and they've paid for the tickets, and then they've also paid an extra fee that goes to the scholarship fund or to the foundation at the school, because that happens at a lot of schools. So I'm wondering what your opinion is on that, and how a university is going to define clearly who's over that $50,000 threshold.
I mean, I think me personally, I do think those are the people that they are trying to avoid in donating these pay for play situations, because somebody who has the means and funds to be able to, have season tickets for 30, 40 years to eclipse that $50,000 lifetime mark, I think they are very undeniably connected to that university. And if they don't have any outside business pursuits that are taking advantage of an athlete's name, image, and likeness, I think all that you are left with is they are donating for the sole fact to get them to play football at that institution. So I think those people are being carved out intentionally in this type of definition, so that you are trying to eliminate those pay for play just because you're an affluent alumni of the member institution of the NCAA.
What about somebody who just literally is spending maybe $2,000 a year? Do you see what I mean? Let's say for their tickets, for their season tickets, and maybe an extra $1,000, and they're not necessarily in that category. They just like going to the games. They're fans.
Well, I think family members that don't have any other association with the university other than being an alumni might be carved out because they don't have a defined relationship. They're not like an agent of the university. They don't work there. If they don't have any sort of defined relationship with the university outside of just, graduating from there, then they might be safe.
If they're just, I buy tickets every year, my family's bought tickets, but, and then all of a sudden I'm now interested in maybe donating to the collective, you see? Right. And that's where when I read it, I was like, ooh, that's interesting. I get what they're trying to do, but what about, because it said over their lifetime.
Well, I think a line of demarcation that Malea mentioned on that is that one of the qualifications on that is that they have to be directed or requested by the member institution athletic department to assist in the recruitment or retention of athletes.
Okay.
So that's I think the line where they're going to separate someone who's just buying season tickets and is just a lifetime supporter who happens to eclipse that mark, and somebody who has the funds that a equipment manager is saying, hey, if you give $30,000 to this program, we might be able to, squeeze out a better tight end this season coming out. So I think that's where it's going to be people who are just fans of an institution, and they, obviously, and they've always been able to give as much as they want to athletic facilities in the school. And that's differentiating between that situation and someone who's trying to use their funds to entice potential players or retain players based on their ability to play football and their skill alone, and really doesn't have any connection to their name, image, and likeness for any other purposes other than playing the sport that they're trying to get them to.
All right, so now we've defined booster. Now we have a situation where a particular athlete has entered into a deal and they are subject to arbitration. And we have another group of students, Chris and Joe, who are going to talk about, tell us what this arbitration is going to look like. How is it going to be set up? Do you think this is going to work?
Hi, and thank you for having me on. My name is Joe Devlin. So the arbitration is going to be run through JAMS, which is a nationally
Or that's what they said at this conference I went to.
Nationally recognized arbitration, generally administered by former judges. And, that's who's going to oversee the proceedings. However, I think kind of fundamentally, there's I think a question of, is this going to work? And I'd say maybe not, because there's a case to be made that the interests aren't lined in an adversarial position. I think an argument can be made that NC2A doesn't have an interest in really restraining the money to these athletes. The NC2A and many athletic departments across the country have just lost significant amounts of revenue, and they're going to continue to be even more short on that revenue as this payment is to the former athletes is made over the next 10 years. And so allowing these collectives to pay players or these third-party entities to pay players is going to be both part arms race, but also part relief valve for the revenue that they're short. So I'm not really sure that there's an adversarial system set up.
Well, the adversarial system is that people don't like having their athletes taken away by another school for a large amount of money when Sac State can't afford as much as Texas, right? So, well, Scadaboo's a perfect example. He goes to ASU probably because he got more money, right? I mean, I don't know. I haven't seen the deal, but Sac State didn't want to lose him. So they want to prevent because of the transfer portal, all their players from being poached, so to speak. So what do you think, Chris?
I think uniquely enough, like California already put in legislation prior to with Nancy Skiller's bill, the SB 206, I believe.
Okay, and what does it say?
And so basically it's saying that it allowed for all the players to be able to receive NIL. But on top of that, in California, if this House case passes, it would seem like this would kind of break the agreement that California already had for their NIL deals that would limit players from receiving their compensation from different places, whether it's a collective or directly from universities in general. So I think overall, once this passes, California in general will probably have a case on their hands that would probably need to go through the AG because...
What is the legislation exactly saying? It's allowing them to receive any NIL money from a school. Is that what you're talking about?
It's not restricting players from receiving NIL money
from a school.
From a school.
Period.
Yes.
And it doesn't matter what amount it is.
No, currently right now.
And so is that going to conflict with the House case?
I feel like if the House case is having arbitration clause that is limiting players from receiving money, then yes, this will break California's law.
It would already. So in California, you're telling me students wouldn't be subject to any amount?
Yes.
So is that an advantage to the schools that are in California?
Should be.
Do you think that the other states will follow and start creating similar legislation?
I believe so, but I don't know if that's already past the mark because this has already been legislation that has been passed years ago. So I don't know if you can go afterwards, but I guess other states can do that, can make their own laws, and I think that's what other states are going to rush to do, to make their own laws in their own states on how they want to deal with this, or if schools will opt into this or not.
Okay, so I know you had been involved in some other legislation in California. What was that legislation about?
That legislation was to, beforehand, it was AB 252, and it was by Assemblymember Chris Holden, and that was just about revenue sharing, just in general. Mm-hmm. And it was basically making a CAP panel board of 21 members to oversee health conditions that players was going through, because a lot of players was not receiving medical insurance, and they had to come out their own pockets on that. Later on, players were having long-lasting effects that was affecting them. We still have issues with agents that are not certified, so they wanted to make sure they would come up with some provisions for that. There was just the issue we came across basically was the Title IX issues, and a lot of schools were claiming that if we would use it this way, that other sports, non-revenue sports, would not be able to continue. They wouldn't be able to fund that, and also the gender inequality would probably go on. So our solution to that was to try to use the school's money and however much they were making and divide that amongst the women's and the men's.
Okay, and that bill did not pass, is that right?
That bill passed the assembly and got stopped in Senate Education.
Okay, so they were trying to kind of address this revenue share that's already come through now with House, okay? So do you think that will not come up again because the House case is supposed to be settled?
True. I think that's already done now. I think there's still components of that bill, like especially health, and probably the recruitment
safety,
process.
yeah.
Health and safety and the recruiting process is in getting agents actually certified or making sure that they go through some type of certification, and just anybody couldn't just go around and do that. There's probably still other things for players who are probably older and have already went through the process so that they could also receive some of that, because a lot of the older players are still hurt and still don't have compensation for this.
So that's another potential lawsuit, really.
Yes.
Yeah. So back to the arbitration stuff. Do you think it's going to work? You don't think it's going to work?
I think it
Joe.
turns into a rubber stamp.
Oh, you think it turns into a rubber stamp? Okay, interesting.
If they have the funds to be able to actually pay that athlete, I think it becomes a check on almost like an escrow. Do they have the funds to pay him? Otherwise, I think people are going to get very creative around ways to create and value. If they're smart, they lean into the subjectivity of these, potential valuations of how do you really quantifying this value. The more subjective it is, whether it's art or anything else, how are you going to put a value on that?
Yeah, it's difficult. All right. You guys are going to talk about how are you going to define all this? What did you guys find out? Introduce yourselves and tell us what topic you're going to talk about when it comes to this arbitration and pay for play and defining that.
So I'm Eduardo. I'm Keith. And we're going to talk about whether or not arbitration is going to apply to deals that were implemented before July 1st, before the settlement becomes concrete, I guess.
This is one of my biggest issues with what's going on. Currently, schools and collectives are entering into deals with players, athletes from every sport. And when this goes into effect on July 1st, I wondered what's going to happen with those deals. Are they going to be subject to the arbitration? Are these deals going to be valid? Okay, so what did you guys find out?
So the NCAA has kind of addressed this. In December, they did a Q&A on the impact of the settlement on D1 institutions, and they actually answered this question. I'm going to quote it. All agreements with associated entities and associated individuals with payments occurring after July 1st, 2025 will be subject to the fair market value assessment contemplated by the settlement.
So I want to be clear to my listeners. If the contracts you're currently entered into right now, if those payments are made after July 1, they are going to be what? Are they going to be valid or not?
Well, that's up to the arbitrators, but they will be subject to the fair market value assessment and the arbitration process.
Unless what?
Unless all the payments occur before July 1st.
Occurred before July 1st? And also, what if they're not a what?
An associated entity or individual.
Yes. Or a publicly traded company, correct?
Mm-hmm. Right.
Okay, so what is your message to people out there and collectives entering into agreements right now?
Okay, my name's Keith again. Personally, my advice would be to be wary of what coaches are offering you, same with athletic directors, because they're constructing rosters right now without knowing their revenue share amounts or their scholarship allotments or their roster limits, or roster availability. So they could potentially just say they're going to offer you a certain amount of money in this NIL deal, but if they don't pay the money to you before July 1st, then yeah, you're likely, as Eddie explicitly stated you're going to be subject to the review of the clearinghouse process or the arbitration process.
Which we're not sure if it's just gonna be a rubber stamp or not. That's the big question, is an arbitrator, after looking at the agreements, how are they gonna determine, and we're gonna talk about fair market value next, but how are they gonna determine what is pay for play and what is a true NIL deal? I mean,
I think there's a lot of uncertainty, and I think a lot of people are probably scrambling right now to get these deals done with, and if they know this, then they'll probably get all the payments out before July 1st. And I'm not sure how like the bigger deals are being structured, but I'm sure they're not being paid up front.
no, they're not being paid up front. That's
So
not how it's working.
All the bigger deals are going to definitely probably be going through the arbitration process, unless the school can somehow pay them out before July 1st, which will probably be difficult.
Yeah, exactly, and it's going to be difficult, especially because these people who are already in agreements you can't, you can renegotiate, but the school is not going to renegotiate with you if you already accepted a deal. I get $500,000, but I don't see most of that until like 5 years from now, where it's like,
A lot of the deals are 4-year deals. So what about a deal that was done 2 years ago? Same thing, right?
Well, I'm sure it hasn't been fully paid out, and until it's fully paid out, they're not in the clear yet.
Right. So do you think they would be subject to the same process, even though it's not current? Like, it's not a current negotiation.
Yeah, I mean, I'm sure they didn't contemplate that they would be scrutinized, and now, look, in July 1st, they're going to be being scrutinized by the arbitration process.
So my message to anybody out there who is running a collective is you need to make sure that in those agreements that you're agreeing to, that on July 1, the House settlement is going to affect, and everything we're agreeing to right now is going to be subject to arbitration. Because you got to protect yourself. See, this is my message to people. You got to protect yourself unless it's a publicly traded company. Okay? That's the only way around it. But what if a publicly traded company is part of your collective? What about that? What about Nike?
I mean, I think a lot of the definition of the associated entities and individuals relies on the fact that they're supporting or promoting a particular member institution. And that was kind of, one of the things we had spoken about before is if there was a situation where if there was a regional collective that, sponsor athletes at multiple different schools, it'd be hard for the NCAA or the court system or an arbitrator to determine that they are providing support to a particular member institution. So I think kind of along your lines, if you're, Keith had good information for a student athlete, but if you were to recommend anything to somebody who is looking to donate to a collective or might be unwittingly donating to a collective, really evaluating what that connection is to the school, and if the donations that you are putting in that collective are going to be over that $50,000 threshold, and if you're really not getting any business benefit out of the money that you're giving and not expecting anything.
Were you guys going to talk about that?
Oh.
Yeah. That's the, Keith, what's the definition for, tell me what the definition is to determine whether it's pay for play versus a valid business purpose. Did you?
Yeah, I captured the standard. The standard I read said that an arbitrator will determine whether the NIL deal serves a valid business purpose or are merely pay-for-play schemes disguised as NIL purposes. Those deals not deemed as fair market value will be rejected, and for athletes, the athlete must end their deal or risk ineligibility, but there also is an appealing process. But I don't have any certain information as this isn't, this hasn't been applied yet. As far as will the athlete be eligible during this review process, or are they ineligible if they don't end the deal, and then they can review?
Here's my concern. How fast do athletics go? Very fast. How slow do arbitrations go?
Months.
So I can't figure out. They're going to have to, unless they structure it like we do In the NFLPA, if a player got fined, okay, they immediately got a letter sent to themselves and whoever represents them, and then we would immediately set a hearing and we would figure out whether the fine was going to be reduced. And I'm thinking that that's got to be the same kind of system because it's got to be fast. If a player is deciding whether or not he or she wants to transfer to another school, and they're in the transfer portal, and they're offered a certain amount of money, it's over $600, the arbitration is going to have to happen in 24 hours. But I haven't ever seen an arbitration happen in 24 hours. Have you?
But can't you only guarantee that expediency if you collectively bargain and, you have unions and you have rights as individuals? There's no reason, I guess, for expedient arbitration if there's nothing holding them to the fire. So that's going to be probably another issue, which I think kind of aligns with the rubber stamp argument that I think a lot of these, especially the smaller deals, are probably going to get pushed through just on the basis of expediency and efficiency rather than actually establishing that fair market value or, making sure these deals are commensurate with the athlete's value.
Well, what happens if the season's starting and you're 2 months in?
It's a great question.
Is the athlete going to get the money? Is the athlete got the money and now they got to pay it back? I mean, you see where there's a lot of issues with all of this. And your season's starting. Okay, basketball season starting, football season starting. So there's some issues with the arbitration stuff that I'm a little bit, or you just go ahead and play and see what happens, but you've already transferred by then. That's the other issue. So, and I think could be some challenges to the arbitration. Does anybody have the 4 standards for how you can challenge an arbitration? I had sent them to you guys.
If the award was procured by corruption, fraud, or undue means, if there was an evident partially or corruption in the arbitrator, if the arbitrator committed misconduct in refusing to postpone the hearing upon sufficient cause shown, or in refusing to hear evidence pertinent and material to the controversy, or if any of the other misbehavior by which the rights of any party may have been predicated, or where the arbitrator exceeded his or her powers, or so imperfectly executed them that a mutual, final, and award upon the subject matter submitted was not made. An arbitration award may also be vacated if it is deemed arbitrary and capricious and or contrary to public policy.
So which part of that you think let's say an arbiter says, yeah, I think this is pay for play. What argument you think you could use?
That the deal was done through corruption, fraud, or undue means.
Exactly.
These are vague terms.
Yeah, they are vague terms, but I think that's the argument that a lot of arbitrations could be vacated because these are for the deals that are happening now that are paid later. Once July 1st comes, everybody's going to know that this is what the rules are. And so maybe they're going to be a little bit, we'll see if the deals are less, right? Do you think they will be?
Yeah, for sure.
You think they will be? What do you guys think? Chris? Joe?
Well, I mean, are they gonna disguise an NIL deal for like an Instagram post as like $5 million and then suddenly someone's transferring? How do you call that reasonable?
I think, for me, this is all fiction. I think all of this is pay to play.
Yeah.
If you look at so I'm a football player and I've got 200,000 Instagram followers. That's great. But why am I tweeting for the Ford dealership in this city? Do my followers even care about buying a Ford pickup truck or whatever it is? How many of them even live in that state? How many of them even live in that city? If you actually dig down, marketing is a science, and hiring some football player to go out there and tweet about your dealership just doesn't make sense. And so whether you're going to pay them $50 or $5,000 or $100,000, I think it's all fiction.
Because you feel like their followers aren't necessarily following them to buy a Ford truck. They're following them because of what
I think only in
sport.
the narrowest of circumstances are they actually delivering a value to someone who is selling a good or a wear. It's almost the most, and otherwise it's just It's
I'd
just
probably
a complete
disagree
picture.
with that because at least in those situations where you have a independent business owner that's reaching out to this athlete to exchange compensation for marketing in whatever way, whether it's a tweet, Instagram post, wearing their shirt around campus, what have you, it's at least a bargain for exchange that can be evaluated and compared with other types of marketing expenses that business would have. Whereas if you're putting money into a collective that's distributing payments to potential athletes or to retaining athletes, there is no second part of that bargain for exchange that you can look to, I guess, even up the equation with the compensation. So when they're donating the money to the collectives to pay for players, the players are getting their X amount of dollars. Their only return in that agreement is to play football at the school, where I think that's where you can directly relate to pay for play. Whereas any consenting entity can negotiate a marketing contract with any other consenting adult to provide marketing services, wear a shirt, do the tweet, where I don't think really the court or the NCAA is concerned with the validity of those aspects. What they really are trying to avoid is avoiding people getting paid money for their skills to play football, because in that way they're a professional, they lose their amateur status, which is always the NCAA's argument, and that's where it becomes pay for play rather than a bargain for exchange between two consenting entities or an individual that they're trading money for services. And I think that's where the courts are trying to say, we want that to happen. What we don't want is just individuals, athletes getting money for the sole purpose of playing their sport at that university by people that have a vested interest in that university's football, basketball, what have you, program doing well.
That's
Malea, were you going to say something?
Oh, I actually was kind of going back to like how I actually had a question for you, separate from, I guess, this little conversation. I was just curious, like, do you think that the parties to these agreements are going to like try to amend the agreement somehow to try to get around these rules, or even do an novation or an assignment agreement so that these associated entities or individuals are no longer a thing? Like,
I think there's a couple things that are going to happen. One of the suggestions that I heard was that these collectives were going to become agencies, almost like they were going to become almost like an advertising agency as opposed to a collective. And then some of them were just going to be moved into in-house to the athletics department under the foundation. So they weren't, quote, going to be a collective anymore. They were going to be under the foundation. And then the revenue sharing piece, it was going to be distributed that way. Do you see what I'm saying? Like the deals or whatever they promised are kind of going to be more under the revenue share aspect versus the collective. But I think one of my concerns with all of it is, and I do think this is happening, where kids, athletes, are entering into deals, and the deal says you're supposed to attend 3 different events and you're supposed to tweet, and I don't know that these contracts are being enforced. And I think the scarier part for an athlete is, did you actually perform? If they asked you to go to 3 events in exchange for your money and you didn't go, then why are you getting the money? Because I think that is something that is they're not talking about because they don't want to talk about that. I'm talking about the collectives and the athletes, because then what is it? It's clearly pay for play, meaning they didn't do what they were supposed to do in the agreement, but maybe they're still getting paid.
right.
I would like to say that even if they did do what they were supposed to do in the agreement, in my opinion, I think I'm more confused about the whole thing, because they would never even be reached out to if they were not athletes for this certain school. So to say that they're not doing that, I mean, you could find anybody with 100,000 followers. I mean, you can make fake followers or whatever it is.
Oh,
Like, they're
that's true.
literally paying these people because they know that their name, image, and likeness, and that who they are as an athlete, and how that's going to make their business look. So to me, it's all going to be pay for play, because you're either, if you're a collective that says I want to be an agency, you're aware that you're marketing towards players. If you're not doing that, or you're just with the athletic departments, you're still associated with athletics. So if these players were never athletes, you would never be reaching out to these people.
Okay, Zach's shaking his, yeah, I get what you're saying. Zach, Zach's shaking his head.
I mean, I just think that's kind of evidence of the other side, where because you're reaching out to these people for the name, image, and likeness, that's why they're getting compensated in the first place. And you're obviously reaching out to these as a business, whether that's a local business, national business, whatever. You are reaching out to these athletes to represent your company in some sort of marketing scenario. So you are paying them, not necessarily to play. You know, you hope they continue to play, so they hope that they can maintain that name, image, and likeness. Mm-hmm. But in essence of the deal is to market your company. So you are paying them for a tweet, you're paying them for whatever. Mm-hmm. Yes, you're utilizing their skills as an athlete, but that is their name, image, and likeness. I feel like if you are purely paying an athlete for their skill on the field, I don't think that falls into the name, image, and likeness realm. I think that falls into the pay-for-play realm. Mm. Because you're not, I think a lot of the court cases and everything like that is wanting to make sure that the athletes profited from their name, image, and likeness.
Right.
Not necessarily profiting from their skills as an athlete.
Right.
And I think when you donate to a collective that doesn't have any business pursuits associated to it, and you're making payments to these athletes, you are paying them for their skills, which, hate to side with the NCAA, but that, you know, does kind of reach past the amateur status and makes them a professional. They're getting paid for their skills as a professional, which I think is what everyone's trying to avoid in the collegiate landscape. And you can do that while also being able to make sure that these athletes get paid for their name, image, and likeness, because they can negotiate whatever deals they want to wear shirts around campus, to tweet certain business, mm-hmm. to show up at certain events and all that stuff. They have the free realm to do that. But it's a fair exchange that has a legitimate business purpose attached to it that's not really shrouded around necessarily their skills on the football field. It's really actually utilizing their
and these
name,
agreements are going to have to be clear on that. Now, I think the agreements maybe are, but maybe that's not how it's being played out. See, that's the thing. I think the agreements on their face look like they're a valid, legitimate business deal. But maybe they are, maybe they aren't.
Hi. Look forward to next week's podcast where we will talk further about the fair market value and how that will be determined. Thanks for joining me this week. I certainly have enjoyed having all my students on my podcast. This will be going on for 4 episodes. So stay tuned and look forward to hearing you next week. Please go to my website at jillmcbridebaxter.com if you want more information about all the different services I provide. Thanks for listening. Have a great week. Thank you for listening to this episode of Representation Without Taxation. Simply stated, I am always and forever about 3 things: protection, advocacy, and trust. To learn more about my fair fee structure, please visit my website at jillmcbridebaxter.com. If what we were talking about strikes a nerve, please subscribe and definitely share it. Until next time, it doesn't matter what the plan is, as long as you have one.